Supreme Court of Queensland is in session. Any person having business before the court, come forward, announce your presence, and you will be heard. Please be seated.
We join today to farewell our friend and colleague, the Senior Judge Administrator, Justice Byrne, and to acknowledge His Honour's 28-year contribution to the administration of justice in Queensland. We're honoured by the presence of His Excellency, the Governor, Paul de Jersey. His Excellency was on the bench when Justice Byrne was sworn in as a judge of this court on 26 July 1989. This ceremony is being streamed to Rockhampton, Townsville and Cairns, where we're joined in the last two centres, respectively, by our colleagues, Justice North and Justice Henry. Justice McMeekin is unable to attend the ceremony, but wishes to be associated with the sentiments expressed. And we welcome in the court itself Chief Justice Kiefel, Justices Bell, Gaigler, Keane and Edelman of the High Court, the Chief Judge and Judges of the District Court, the Judges of the Federal Court, led by Justice Dowsett, who has the rare and I think possibly unique distinction of being a longer-serving judge than Justice Byrne, and like His Excellency, was on the bench when Justice Byrne joined it. We welcome too Judges of the Family Court and the Federal Circuit Court, the Chief Magistrate and Deputy Chief Magistrate, the Deputy President of the Industrial Court, the President and members of the Land Court, and tribunal members. There are many of our former colleagues, the retired judges, present, a number of whom are on the bench to see Justice Byrne sworn in and now see him sworn out. At the bar table, we're joined by the Attorney-General, Ms Darth, and we welcome too the Shadow Attorney-General, Mr Walker. We welcome the leaders and the many members of the profession, representatives of the Department of Justice, members of the Academy, members of the public who've joined us. As you can see, the Banco Court is filled to capacity and there's also an overflow court. Now, I must extend a very particular warm welcome on behalf of this bench to Justice Byrne's partner, Ms Jennifer Coleman, who has been a treasured member of the court community for many years. And we acknowledge too all of Justice Byrne's family and friends, noting with a special pleasure the presence of his brother Robert and his wife Morella. Then there's a row of special guests which you cannot have missed, Justice Byrne. The members of the bar have very graciously moved aside from their usual seat at the front of the public gallery to allow your former associates to line up. There are 18 of them. They've come from across the country. They're seated with your secretary, Ms Klein. The fact that so many of them have made an effort to be here speaks volumes for the kindness concealed behind that formidable judicial persona. Justice Byrne, you were a relatively young appointment to the bench at 40. Your professional progress had been uncommonly rapid, although your commencement at the bar was delayed a little by your undertaking articles and then a master's degree. You quickly became a star of commercial litigation, taking silk after an extraordinarily short 9 years in practice. You'd practiced 7 years as a silk before becoming a judge. Your appointment was very enthusiastically welcomed. Those short periods of practice, less than a decade as a junior and then as a silk, were then succeeded by almost 3 decades of service on the bench. You might have been forgiven for growing jaded, but you didn't. At your swearing in, the President of the Law Society said this: "Your Honour will discharge the onerous task of judicial office with great distinction, unselfish commitment and unstinting dedication to the task." Things are often said in these courts which prove to be less than accurate, but not that statement. That's a precise description of what you have done. As well as your dedication to your judicial role, your leadership has been important. Your presidency of the Australian Institute of Judicial Administration, your chairing of the Council of the National Judicial College of Australia, and most importantly, your last 10 years as the Senior Judge Administrator of this court. You worked unselflessly in all of those roles, and in 2013 your distinguished service to the judiciary and to the law was recognised when you were appointed an Officer of the Order of Australia. I am personally indebted to you for your wisdom and support over the last 2 years. I look forward to the benefit of Justice Lyon's astuteness and energy, but I will miss your steady counsel and your ability to see around every corner of an issue. And I want to express the gratitude of all of us on this bench for all you did in providing, with former President McMurdo, leadership of this court at a time of crisis. You conducted yourself with great fortitude, inspired by concern for the independence and integrity of the court. The importance of the part you played and the strain it placed on you, I think, are unlikely ever to be understood fully outside our number. Finally, can I say that I sincerely hope that you prove better at retirement than you do at weekends, because it's a well-known fact on this court that you can be found in here working every Sunday morning. At your swearing-in, you spoke of the future in alternative dispute resolution, and it's possible that that area will now attract your attention. Somehow I see you in arbitrations, not mediations. We all wish you well in what will undoubtedly be a new set of pursuits. Having said that, and recognising the challenge for all the speakers of covering nearly 3 decades of service in anything like a reasonable time, I will stop there and let others continue with your praises. Madam Attorney.
May it please the Court, I'd like to start by respectfully acknowledging the traditional owners and custodians on the land on which we hold this very important ceremony this morning and pay my respects to the elders past and present. Can I acknowledge His Excellency, the Honourable Paul de Jersey, Governor of Queensland, the Honourable Catherine Holmes, Chief Justice, the Honourable Susan Kiefel, Chief Justice of the High Court of Australia, and Justices Bell, Gallagher, Keane, Edelman of the High Court of Australia. Can I acknowledge, of course, the Honourable John Byrne, Senior Judge Administrator. Can I acknowledge the Honourable Walter Sofronoff QC, President of the Court of Appeal, Chief Judge and Judges of the District Court. Can I acknowledge Justices, of course, of the Supreme Court, Judges of the Federal and Family Courts and retired judges and tribunal members here, the Chief Magistrate and members of the Magistracy, Solicitor General Peter Dunning QC, Mr Ian Walker, Shadow Attorney General, Mr Christopher Hughes QC, President, Bar Association of Queensland, and Elizabeth Shearer on behalf of the Queensland Law Society, distinguished guests from the profession and community, and especially friends, family, and all of the former associates of Justice Byrne that are joining us here this morning. That was a long list of acknowledgements, but I believe it is a reflection of the standing in which Your Honour has been held in the legal profession and the judiciary over many years, and the willingness of so many to want to acknowledge and praise your contribution to the legal profession. It is a pleasure to join the court this morning, and His Honour Justice John Byrne AO RFD is one of the most experienced and respected judges on the Supreme Court of Queensland, and I want to align myself with the comments made by the Chief Justice. Those on this side can't truly understand the benefits and the mentoring that has occurred within the judiciary itself, but I want to echo the comments made by the Chief Justice and thank Your Honour for your contribution to your fellow colleagues. But today we mark your Justice Byrne's contribution of over 28 years to the judicial landscape and the Queensland community. I will leave it to others to talk about potential antidotes or past stories, as I'm sure they will, but I do want to acknowledge your exceptional and extraordinary legal career. Justice Byrne was educated at Brisbane Boys College and the University of Queensland, graduating with a Bachelor of Arts in 1969 and a Bachelor of Laws in 1971. Justice Byrne commenced his legal career as an articled clerk, was preferred for Morris, Fletcher and Cross, and he was admitted as a barrister of the Supreme Court of Queensland in 1972. In 1973, His Honour completed postgraduate studies at the University of Michigan, graduating with a Master of Laws. And in 1974, he commenced his practice at the bar in Brisbane, taking silk on the 25th of November 1982. On the 25th of July 1989, Justice Byrne was appointed as a judge of the Supreme Court of Queensland, and on the 24th of August 2007 was appointed Senior Judge Administrator of the Supreme Court of Queensland. His Honour has never shied from his responsibilities in the trial division of the Supreme Court. He's been involved in notable, novel and sometimes notorious cases during his time on the bench. This includes vexatious litigant cases such as the 2010 case of Guilfoyle and others and Condi, upheld on appeal, and high-profile criminal trials, including Patel, Sicker and Baden Clay. Since 2007, His Honour has managed the trial division of the Supreme Court as Senior Judge Administrator. His legal intellect and leadership to the court has been paramount in guiding the court through the challenges of these times. I'd like to personally thank His Honour for his advice and reflections while I have been in this role. His insights have been appreciated, and I also express my gratitude for His Honour's advance advice on his retirement earlier this year. This has provided for a smooth transition within the court and within the post of Senior Judge Administrator. Justice Byrne's contributions speak to a life that has been spent in service to others, service to his peers among the judiciary, to current and future generations of lawyers and legal scholars, and to the community at large, including military service. And this is reflected in your service over many years, and that service includes from 1982 to 1988. Justice Byrne was a member of the board of the law faculty at the University of Queensland and chaired the advisory committee to establish the law school at Griffith University. He was also a member of the Griffith University Law Faculty Visiting Committee from 1994 to 1999, and during the same period was a member of the Bond University Law School Advisory Board. Justice Byrne was a member of the Supreme Court Library Committee from 1985 to 1989 and has been a member of the Supreme Court Rules Committee. He has served as a member of the Litigation Reform Commission from 1994 to 1996. His Honour chaired the National Judicial College of Australia, a body which provides programs and professional development resources to judicial officers in Australia. He was a member of the Council of the Australian Institute of Judicial Administration from 1997 to 2006, and he served on several committees and was president from 2004 to 2006. Justice Byrne was made a life member of the Australasian Institute of Judicial Administration in 2012. Justice Byrne has also served the community and our country. Justice Byrne served in the Infantry Corps in the Army Reserve for over 19 years, finishing his service with the rank of Lieutenant Colonel. He was awarded the Reserve Force Decoration. Justice Byrne was also Honorary Secretary of the Queensland Council Social Service from 1975 to 1983 and a member of the Board of Governors of the Australian Council of Social Service from 1976 to 1977. He was made an Officer of the Order of Australia in 2013. These are significant achievements for any member of the judiciary or community. These extraordinary personal qualities have been complemented by His Honour's fondness for direct communication and appetite for analogy, metaphor and antidote. On behalf of the government, I thank Justice Byrne for his extraordinary contribution to the legal profession, to the judiciary and to the rule of law. He will be fondly remembered in this place, and I hope, as the Chief Justice has reflected, will continue to contribute in some other way after he leaves this great place. On behalf of the Queensland Government, it is my pleasure to wish Justice Byrne well in all future endeavours. May it please the Court.
Mr Solicitor General.
May it please the Court.
Mr Hughes.
If it please the Court, Chief Justice, Justices of the Supreme Court of Queensland, including former justices, and of course in particular, Your Excellency the Governor of Queensland, the Honourable Paul de Jersey. Judges and members of other courts and tribunals of Queensland, including in particular Chief Judge O'Brien of the District Court, Chief Magistrate Renato and President Kingham of the Land Court, judges and members of the federal courts and tribunals in Queensland, and in particular the Chief Justice of Australia, the Honourable Susan Kiefel, and Justices Keane, Edelman, Bell and Gagler of that court. Justice Dowsett, in particular, I wish to acknowledge, Madam Attorney, Shadow Attorney, members of the profession, ladies and gentlemen, it would be remiss of me not to commence by dwelling, albeit briefly, on the presence here today of the Honourable Paul de Jersey, who presided over this court with such enormous ability and dignity for so many years. Your Excellency has, to the members of my association, always been a welcome sight in the courtrooms of this court. But we are not here today to welcome back a great man who has contributed so much to the law and to justice in the state. We are here to farewell another man who has made a similar contribution. Justice Byrne, you've sat on this court for so long, nearly 3 decades, that for many of my members, it's difficult to remember that you were in fact once a barrister, and a very good barrister, and that in fact you did once have a sense of humour, and a very good sense of humour. Although we all remember that for 10 of those years you were Senior Judge Administrator, which must have sorely tested at times that sense of humour. You are certainly a product of Brisbane, although I have rarely seen you drinking rum. You were born in the city and enrolled at Brisbane Boys College, both, I might say, not long after dinosaurs ceased to roam this earth. You were educated at the University of Queensland, where you obtained degrees in arts and law, and in a refreshing twist on an occasion such as this, you earned your master's degree not in the dank halls of the old country, surrounded by the Atlantic, but in Michigan, in the New World, surrounded by the Great Lakes. As we've heard, Your Honour was admitted to the bar in 1972. You took silk at the very young age, in your early 30s, in 1982. You were appointed to this court in 1989, and 10 years ago you were made Senior Judge Administrator. As we've heard, Your Honour's given service to the Army Reserve. Indeed, you were one of the last couple of members of this court, the other I suspect is Justice Goddison, to have given military service as a General Service Officer. The colours on your chest indicate the significance of your military service, just as the colour on your head indicates the length of your period on the bench. You've made remarkable contributions to the administration of justice as a judge of this court, to the rules of court, to the Supreme Court Library, and to alternative dispute resolution, and all with distinction, a distinction recognised by your appointment as an Officer of the Order of Australia in 2013. As a Senior Judge Administrator, as we've heard, you led by example and listed before yourself some of the most notorious criminal trials in recent times and some of the more difficult civil trials. An appearance before Your Honour, if you're a young barrister, as many of us were, or have been, since the late 1980s, always involved a great deal of pleasure. Pleasure for Your Honour, that was. Initially, most of us were stupefied with terror that we'd failed to research the latest vaguely relevant decisions from the obscure jurisdictions of the Americas and even occasionally the Old World. Most of us feared that we'd not thought of the true solution to the legal problem at hand. That was, of course, the solution that Your Honour tumbled upon, at a speed which left some of us bemused, most of us impressed, and all of us floundering in your judicial wake, trying to regather our submissions. The speed at which Your Honour tumbled to the appropriate result was matched only by Your Honour's tenacity in guarding that result from tedious and often, no doubt, irritating submissions which might have pointed faintly to some alternative conclusion. Lest it be thought that Your Honour's teasing of young and enthusiastic counsel was a preoccupation, I hasten to add that Your Honour was not immune from similarly dismantling the mature and the senior advocates before you. However, it must be said, there was no doubt that most of us who appeared before you recognised that your conduct in court was designed to achieve two very clear results. First, the gathering of all available research and knowledge with respect to the facts and the law in any given case. And second, the achievement of the appropriate result according to law in any given case. Like many members of the association, I've admired you both professionally and personally, rather than feared you, for a long time. You have given me advice in my present position. I have admired not only your capacity as a lawyer and a judge and your sharp wit, but also your exceedingly dry sense of humour. I've also witnessed on occasions your wet sense of humour, not just in your chambers after court, in your days at the bar, but also in the bibliotheques and bistros of Paris, where I had the honour of spending an extended and illuminating time in Your Honour's presence many years ago in the company of your partner Jennifer and my wife. At the bar, Your Honour most famously shared chambers for a time in what was then the MLC building with a relatively modest and moribund group of underachievers. Justice Dowsett, a former judge of this court, and for some 2 decades a judge of the Federal Court. Justice of Appeal Philip Morrison, and the unforgettable, wondrous Ted Lennon QC, who was perhaps rather romantically described by the legendary David Jackson QC as a light and delicate silk, more of a Tiffany silk than a true heavyweight Oriental silk. On occasions, young barristers such as myself would enjoy a wet Friday evening's hospitality in that legal powerhouse. Of course, Your Honour had also shared chambers in the very beginning with another gifted young counsel who at that stage went by the name of Paul de Jersey. Your Honour's contribution to the military, to the education and advancement of lawyers, both practitioners and judges, to the Australian Council of Social Services and to social services generally, and to the law faculty of the University of Queensland are all recognised and applauded by the Bar Association. But all things, Your Honour, must come to an end. On behalf of the Association, might I express today only one regret about Your Honour's career, and that is this. Your Honour chose many years ago no longer to sit in the appeal division of this court. As a result of that decision, there can be no doubt that the jurisprudence of this state has been diminished. Stories about Your Honour's future abound. The most popular seems to involve talk of Tasmania and of rescuing animals. Some talk of reading a lot of books. I've yet to hear anyone suggest the Holy Orders, but I understand that your Sunday mornings, from what the Chief Justice has said, which otherwise have occupied yourself with court work, will now be free. So perhaps that's an option Your Honour should seriously consider when the church bells ring. I have no doubt, and neither do my members, that whatever Your Honour turns your hand and your mind, success will follow. On behalf of the barristers of Queensland, Justice Byrne, I wish Your Honour and your partner Jennifer a wonderful future, which we trust will be just as exciting and will contribute just as much to the society in which you have lived as your illustrious past. If it please the Court.
Ms. Shearer.
May it please the Court. I'm pleased to be here today to acknowledge, on behalf of Queensland solicitors, the career of one of the bench's leading lights. I convey the apologies of Queensland Law Society President Christine Smythe, who is unable to be here today, but has asked me to pass on her personal congratulations. Your Honour's many achievements at the bar and the bench have already been touched upon today, and so eloquently that I could not meaningfully add to the deserved praise. I would like to highlight a less well-known aspect of Your Honour's time on the bench, your role as a much-beloved mentor and friend to your associates. Researching this speech, one constant was the genuine affection with which Your Honour's associates remember you. Stories of personal kindness and reaching out in times of need were plentiful. It is clear your Honours associates considered you a mentor, a teacher, a leader, but above all a friend, an enviable legacy, as impressive as your many other meritorious achievements. Much of your compassion must have rubbed off on these associates, as I understand many of them have become solicitors. While at the bar, Your Honour was a member of the Army Reserve, which of course was known as the Citizens Military Force when Your Honour's career there commenced. Your nearly 20-year career saw you rise to the rank of Lieutenant Colonel and to the command of the Officer Cadet Training Unit at the Sanananda Army Barracks at Wacol. Training cadet officers in the Army Reserve was an example of Your Honour's well-known desire to educate people, especially those who came before you in the applications list. I am informed that few ever forgot those valuable lessons, nor had any desire to sit another class. A practitioner appearing before Your Honour for the second time was always a prepared practitioner. They learned well Your Honour's favourite adage, time spent on reconnaissance is never wasted. Your Honour was also known as an innovator, taking over a busy commercial applications list, utilising the then unfashionable alternative dispute resolution to ease the pressure and modernising processes in many other ways. Your Honour's desire to give back to the profession also had a formal educative side, presenting at many seminars over the years. I pass on my particular thanks for Your Honour's presentations at the Queensland Law Society's events, which included being the keynote speaker at our criminal law conference and presenting at last year's symposium. But even prior to your appointment, when an eminent silk, your interest in innovation and education combined when you were a presenter at the Queensland Law Society's Innovative Advocacy Training Program, known as the Simulated Opposed Action Program, or SOAP. This also sometimes involved an informal way of giving back, as Your Honour embraced another adage that the only time junior solicitors consumed good champagne was when a silk was buying. As several junior solicitors can attest, there were no bubbles like soap bubbles. Appointment to the bench did not diminish Your Honour's enthusiasm for hard work, holding many positions with the Australian Institute of Judicial Administration, being on the steering committee of the Supreme and Federal Court Judges Conference, and the convener of Better Resolution Litigation Group, to name just a few. Fitting all of that in may have led Your Honour to becoming a favourite of law students everywhere, in that your judgments were always succinct. Indeed, I am told, had Your Honour written War and Peace, it would have been 10 pages long, including the index. I note Your Honour was also very particular when it came to what could be allowed before a jury, noting that once they knew something, they could not unknow it. To illustrate the problem, counsel were often invited to try not thinking about a blue horse. And I think the profession has more insight into that analogy now, that we have to try and think of the court without Your Honour on it. You may be having slightly less difficulty thinking of your life without the need to deal with lawyers. Mentioning even half of Your Honour's impressive achievements would take too long and rob me of the brevity which Your Honour has traditionally favoured. So in closing, I will say the solicitors of Queensland wish Your Honour all the best in a well-earned retirement.
Justice Byrne.
Your Excellency, Chief Justice, Attorney General, judicial colleagues, including Chief Justice Kiefel and Justices Bell, Gageler, Keane and Edelman of the High Court of Australia, Justice Dowsett, the Senior Federal Court Judge resident in Queensland, Chief Judge O'Brien, Chief Magistrate Renato and Judge Kingham, President of the Land Court, the Shadow Attorney General, Mr Walker, Mr Hughes, Ms Shearer, members of the legal profession, retired judges, ladies and gentlemen. My departure from the court next week coincides with the end of my second 5-year term as Senior Judge Administrator. Other factors indicate that my leaving is timely, among them that fully 20 judges appointed to the court after me have, through death, retirement or resignation, already gone. That my present associate is the fourth such who was not even born when I became a judge, and that only 2 judges appointed to the court in more than a century have been here longer. The grandson of one, Justice Douglas, sits with me today. The other is His Excellency the Governor. The Governor's remarkably successful 16 years as Chief Justice finds a physical expression in this building, which he persuaded the government of the day to construct. Your Excellency, you honour me and all of us by your presence. A valedictory can be a time for reflection. It is certainly an opportunity for an expression of gratitude. 47 years ago, my practical experience of the law began as an articled clerk in what was then the largest law firm in the state. Ethical standards were high, and the partners were committed to service, to their clients, to their profession, and through membership of community organisations, to the public. The partners recognised that their duty to put the interests of clients ahead of their own constrained expectations about levels of remuneration. They sought a comfortable living from practice. They did not appear, however, to aspire to the riches of those pursuing self-interest in commerce. There were income targets, but in those gentler days, there were not the pressures of the billable hour or a 6-minute charging unit. The lawyers at the firm also mostly took to heart the message printed on a Queensland Law Society bumper sticker that a former president of the Society, Justice Byrne, kept on his fridge. It read, "Solicitors solve problems," which is, as it should still be. Although qualified to be a solicitor, I was admitted as a barrister. Then for about 6 months I worked as a law clerk. To accommodate concerns of the Bar Association, the firm accepted that I would not exercise a barrister's rights of audience. After returning from studies in the United States, I joined, as you have heard, a small set of barristers' chambers, where 2 of my friends and contemporaries from law school, Paul de Jersey and John Dowsett, were already hard at work. I learned from them, as well as from quite a few of the 130 or so barristers then practising in Brisbane. The 70s and 80s have been described aptly, I think, as a golden age for the Queensland Bar. By 1980, when John McCrossan joined this court, there were about 10 senior counsel of outstanding ability practising in Brisbane. All but one of them, sooner or later, answered the call to judicial service. In those days, the 2-counsel rule operated. Anti-competitive it may have been, but it did have the beneficial effect that junior counsel like me learned much, quite quickly, working with and appearing against truly talented silks. My practice was almost exclusively civil, but I did appear in 2 criminal trials in my second year at the Bundaberg District Court, in succession before the formidable Judge Pat Shanahan. In the first trial, my young client was found not guilty of stealing a coat. His obvious pleasure at the verdict was diminished somewhat when, before the jury had even left the courtroom, the judge stood him up and told him, "The next time I see you here, you better have your toothbrush with you." The second trial had not progressed far when, with firm judicial encouragement, the prosecutor elected not to proceed. So, with an unblemished record, I retired from criminal trials. Commercial litigation absorbed much of my time at the bar, and that area of conflict remains my main intellectual interest in the law. Those who toil daily resolving commercial disputes, in court and out of it, usually are too occupied doing so to reflect on the societal value of their labours. Efficient markets for services and commodities generate wealth, and a nation's prosperity depends substantially on the effective enforcement by courts of contracts and rights in property. One of the pleasures of my judicial life has been observing advocates, barristers and solicitors ply their craft well. I have enjoyed seeing skillful, thoughtful barristers and solicitors bent on achieving a useful result for the client exercise discrimination in selecting the issues raised and the arguments advanced, taking only those points that have fair prospects of success in cases that are properly prepared. My meagre exposure to crime meant that the first summing up I heard from a Supreme Court judge in a criminal trial was one that I gave. Chief Justice McCrossan prepared me for that. Aware of my lack of experience, he cautioned me, "John, I hope you're not going to make the mistake of trying to help the jury," proceeding to explain that to sum up was to sit for an examination by the Court of Criminal Appeal. Criminal courts help to maintain social harmony, and in the last decade, the court's criminal jurisdiction has engaged more of my attention. Ordinarily, we list the more complex trials before the more senior judges. That listing practice does, however, assume that Samuel Taylor Coleridge, himself the uncle of a judge and the great-uncle of a Lord Chief Justice, did not have judges in mind when he said that generally experience, like the stern lights of a ship at sea, illumines only the path which we have passed over. Watching juries has been fascinating. Much is expected of jurors: to set aside other pursuits, sometimes for weeks, to cooperate with strangers, working towards a common conclusion in occasionally emotionally charged cases, to sit and remain silent for hours on end while information is communicated, mainly orally, and then to apply instructions from the judge that are not always easy to grasp. For all that, the response of jurors to their burden is impressive. As you have heard, I have had the good fortune to lead two bodies that serve the nation's judiciary: the Australasian Institute of Judicial Administration, which aims to achieve excellence in courts and tribunals, and the National Judicial College of Australia, which enhances the professional development of judges and magistrates throughout the country. The governing councils of both those organisations include people who are not judicial officers. For example, 2 of the 6 members of the Council of the Judicial College are appointed by the Attorneys General of the Commonwealth and the States and Territories. In the 4 years that I chaired the College Council, those appointed by the Executive made valuable contributions. The Institute and the College could not function without financial assistance from government. And as I see it, the work of these organisations exemplifies the advantages that can be secured by appropriate executive involvement with the judicial branch. Attorney General, Ms Shearer and Mr Hughes, I thank you for the generosity of your remarks. Ms Darth, I have appreciated the courtesies which you have extended to me in our dealings, as well as the careful way in which you have approached the selection of judges of the court. Mr Hughes and Ms Shearer, the dependence of the judges on the competence, character and industry of practitioners who conduct cases in the court is plain for all to see. What is not always sufficiently acknowledged is the contribution made by leaders of the legal profession to public understanding of the courts, in particular in explaining why a diligent, competent, incorruptible, independent Supreme Court is essential to the rule of law in Queensland, a proposition that could not be doubted by anyone who has reflected on recent events affecting the judiciary in Poland, Turkey or Venezuela. It is to ask a lot of prominent practitioners to put aside the cares of a busy practice, to speak with the rest of the profession and to engage with the wider public about the importance to the welfare of our society of an independent, capable Supreme Court. Fortunately, when in recent times the need arose, retired judges of this court and practising lawyers of integrity spoke out. Judges are not self-sufficient, and there are others who deserve thanks. My 28 associates, many of them here, some from afar, have lightened my load, and they have often brightened my day, and not just because their annual turnover has meant that I can tell the same old stories year after year to a receptive audience. Their exuberance has, for me, been, in a word, rejuvenating. An abiding interest of mine has been following their later achievements, among them a Rhodes Scholarship and triplets. I am grateful to my executive assistant of 8 years, Lynn Klein. Not without justification, she worries about how I'll get by without her. My administrative duties have brought me into contact with many registry and other staff of the Department of Justice and Attorney General. As long ago as 1889, it was established by a decision of the full court that all court officers are subject to the authority and control of the court, something that departmental officers assigned to the court accept. My relations with senior public servants, most recently Director General Mr David Mackey and the Principal Registrar Ms Julie Steele, have been comfortable and productive. But I also have memories of many other conscientious, able staff who strive to facilitate the administration of justice, including bailiffs, list managers, team leaders, those who process the thousands of new files and probate applications every year, and those who help the thousands of citizens who serve as our jurors. I thank them all. My fellow judges, past and present, have given me much assistance. Their cooperation has been vital to the court's capacity to function during my 10 years heading the trial division. My colleagues who sit to dispose of the business of the Court of Appeal and the trial division already know from private conversation the extent of my respect for them, as well as the depth of my appreciation for their dedication to the discharge of their responsibilities. I leave the court in very capable hands. My partner, Jennifer, has in many ways supported me throughout my years on the court. This public event is not, for me at any rate, a time to relate private concerns. But I can tell you this. Jennifer's invariably sound advice has included guidance on how better to compose a summing up to enhance jury comprehension. And she has tried her best to keep me level-headed with timely encouragement to address my several failings. It is, as I think we all know, showtime in Brisbane, an exhibition with many attractions, including those whirling devices in Sideshow Alley that throw screaming children around. As I look back over the 28 years during which I have been privileged to share in the exercise of judicial power, I think of the adolescent who, having been tossed about and turned over on one of those machines, steps off and with a mixture of exhilaration and exhaustion exclaims, "What a ride." Thank you all so much for being here.
You're all very welcome to join us for morning tea in the gallery outside. Let the proceedings be recorded. Adjourn the court.